Hello and welcome to the December edition of Seat at the Sitting. I'm Nate Kazmarek, Vice President and Director of the Practice Groups. This afternoon, we are certainly looking forward to a great discussion of the upcoming oral arguments before the Supreme Court. But before we get to the panel, I wanted to note that we just completed the largest National Lawyers Convention in our organization's history. And if you missed any of the more than 30 excellent panels and addresses from 2 weekends ago, they are now available for your viewing online. To watch the NLC videos with your friends and family at upcoming holiday gatherings, please visit the Federal Society's YouTube page. Turning now to our discussion today, for 90 minutes or less, we're looking forward to a great preview of the SCOTUS docket for the next month. Our usual disclaimer applies. All opinions expressed during this program are those of our speakers and not FedSoc. Our moderator this afternoon is Tessa Schur. Tessa, we are happy to have you join us. I know the House is out of session right now. Are you busy prepping for Thanksgiving?
Oh, the work never stops, Nate.
I assumed as much. Well, we're really grateful that you could join us. We appreciate your time, lending your time and expertise to today's program. Tessa serves as committee staff in the U.S. House of Representatives. Prior to her work in the House, Tessa was a litigation associate at the nonprofit law firm, the Fairness Center. Before that, she counseled high-level leadership at the U.S. Department of Justice Office of Legal Policy, or OLP. Tessa is a graduate of Penn State Dickinson Law School. Full bios for Tessa and our panel are available for your review on our website. The panel today will cover upcoming cases, and then we'll go to audience Q&A. So please think about the questions you'd like to direct to our experts in advance. We are streaming on many Federal Society platforms this afternoon, but if you joined us by Zoom, your questions can be submitted with the Q&A function at the bottom. We will answer as many audience questions as we can get to. With that, let's get started. Tessa, the floor is yours.
Good afternoon, everyone. Thank you, Nate, for the introduction, and thank you to the Federalist Society for inviting me to moderate today's panel. I'm pleased to do so today in my personal capacity, so please note that any opinions I state are mine only and not my employer's. So we will be discussing 8 cases this afternoon. Our panelists will share their opening remarks in the order in which the court will hear oral argument this term. And then afterward, I will go ahead and summarize the remaining 3 cases. As Nate said, we'll have a question and answer session, so please get your questions ready, send them using the question and answer feature in Zoom, and we'll get to as many as we can. So with that, I would like to now introduce our esteemed speakers in the order in which they will speak. As Nate said, you can find their full bios on the Federalist Society's website. First, we have Mr. Jeff Steyer. He's a senior fellow at the Consumer Choice Center. He's also a senior fellow at the Taxpayers Protection Alliance, and he's a policy advisor to the Heartland Institute. Jeff spent 2 decades advancing public health and defending liberty, and in that space, he's a frequent contributor to various media outlets and academic discussions. Next, we have Mr. Eric Kniffen, a fellow at the Ethics and Public Policy Center, where he works to protect and strengthen religious liberty. Eric practices law at Kniffen Law PLLC, where he helps religious organizations and individuals protect their liberty and advance their missions. Next, we have Ms. Alexandra Shapiro. Alexandra is an experienced trial and appellate lawyer who's won appellate reversals in many criminal and civil cases. In her more than 30 years of practicing law, Alexandra has represented prominent Wall Street professionals, public officials, and major public and private companies. Next, we have Mr. Boyd Garrett. Boyd is an associate at Wiley Rain LLP, where he litigates in federal and state court and before federal agencies on issues of administrative law and statutory interpretation. He served as a law clerk for the Honorable Richard J. Leon on the U.S. District Court for the District of Columbia. And last but certainly not least, we have Mr. Michael Pepson, Regulatory Counsel at Americans for Prosperity Foundation, which files amicus briefs in federal and state courts and public comments in federal and state regulatory proceedings. He's also special counsel for administrative law at Cause of Action Institute, where he has been involved in complex civil, criminal, and administrative litigation. So again, thank you all very much for joining us today and for sharing your experience with us all. I will now turn it over to you, Jeff, to start us off with our first case.
Thanks, Tessa. So the FDA versus Wages and White Lion is a case about the Administrative Procedures Act and whether the FDA was, as the Fifth Circuit said, arbitrary and capricious in terms of regulating e-cigarettes. The Tobacco Control Act is the subject matter at play, where the FDA was required to issue a rule to decide how e-cigarettes are going to be regulated. Congress actually, way back in 2007, foresaw lower risk alternatives to smoking and wanted a pathway for those products to be authorized. The FDA, if they were sitting here, would remind us that they authorize products, but they don't approve them. For whatever reason, they don't want to be approving lower risk alternatives to cigarettes, which still kill 480,000 or so Americans every year. So there is a pathway to approve these lower risk products. And the legal standard is that those products have to be appropriate for the protection of public health. And through my work dealing with how do we regulate innovative products that could improve our lives while at the same time minimizing risk to society, the FDA was trying to come up with what does that mean? What is appropriate for the protection of public health? And I was in loads of public meetings with the FDA and industry and public health advocates, where the agency said basically it's a balancing test. We have to weigh on the one hand the benefit, and those benefits are lowering risk to adult smokers who quit smoking completely, those benefits would be very significant, versus the risks. The risks of youth usage, the risks of adult smokers who may have quit now using e-cigarettes, and therefore there is some risk to those e-cigarettes, and putting everything on each side of the scale and weighing it out. And throughout that process, industry was begging the agency to, as agencies tend to do, is say, what are the thresholds that we need to meet to show you that it is, as the statute requires, appropriate for the protection of public health, so that these products can be authorized and therefore legal to market in the country. Right now, we are in a place where only a handful of products have been authorized, fewer than 30, and none of those products are the flavors that adult smokers have chosen to quit smoking. So while there are some 24 or so products that have been authorized, they represent probably 1% or less of market share of a very robust illicit marketplace, or in some cases, a gray marketplace. So it's really important to adult smokers to have a choice, and they are very engaged and concerned about how the FDA is regulating these products. Obviously, it's also important to businesses, especially American small businesses, like Wages and White Lion, which is a small manufacturer in Texas, small to mid-size manufacturer of nicotine liquids that are used in e-cigarettes. And many e-cigarette companies have gone out of business since the FDA began their crackdown on e-cigarettes. And because smokers see these as life-saving, smokers as well as many in public health see these as life-saving products to help adult smokers who either can't quit using nicotine or who choose to continue using nicotine to have a product that's significantly lower in risk. And at these pub meetings that the FDA held prior to finalizing their rule, industry wanted to know what the standards were. And other than telling us that there was a test to weigh both of those pros and cons, the FDA never actually put out standards. But one thing that I think the court may weigh in on here is the ongoing problem of what we call rulemaking by guidance. So under the Administrative Procedures Act, there's a process for a rulemaking, and that doesn't apply for guidance. So the FDA issued lots of guidance And obviously, it would be wise for regulated industry to follow that guidance from the agency when the rule itself doesn't give you much in the way of specifics. So what happened here was, in the wages and white lying case and in many other cases, out of the more than 1 million applications that were filed for what's called pre-market tobacco applications, or PMTA, in those cases, companies wanted to know, well, what do we put in the application? And they really didn't know. So the big companies, some would say this is a classic example of regulatory capture, where the big companies had the money to put in really expensive applications and throw everything in there. Those are the ones that got authorized, the big tobacco, if you will, e-cigarette applications. And many of the small and middle-sized companies really had no chance. But Wages and White Lion, which was doing business as Triton, was one of many companies that put in a really substantial application to show that their application would meet that appropriate for the protection of public health standard as set forth by Congress. And what happened was, in these guidance documents, the FDA said, look, we're really concerned about youth vaping, and we want to see your marketing plan. We want to make sure that you're not going to be marketing to youth. And Wages and White Lion was one of many companies that did that put in their marketing plan. But the FDA, as many in the industry and the harm reduction community warned the FDA, there are going to be millions of applications, because the FDA required that each application be different for each product. So if you had a high milligram, low milligram nicotine, if you had different flavors, if you had different devices, each different SKU for each different product required its own application. So in fact, the FDA was overwhelmed by over 1 million applications. And what we learned was that the FDA kind of short-circuited the review process and said, you know, if there are flavors, if there are products that don't have longitudinal studies, long-term studies to show the effects of these products, we're not going to authorize them. And what the Fifth Circuit found en banc was that the FDA, not only did they not give the companies enough information about what needs to be in an application, but when they said you have to have marketing data, and when the FDA, in an effort to get through their 1 million+ applications, threw out a lot of the applications as invalid, as getting a marketing denial order because they didn't have longitudinal studies, companies like Wages and White Lion said, wait a second, we gave you the marketing study. And it turns out the FDA never even read the marketing study because it didn't have the longitudinal studies. The FDA did say that we, at a very late in the game, that we think it would be beneficial to see longitudinal studies, but because of all sorts of changes that were going on with when the deadline for an application was, the guidance document that said it would be helpful, not necessary, but helpful in FDA's defense, said it would be helpful to have longitudinal studies. That guidance document came after the deadline to submit an application. And certainly after the time it became impossible to do a longitudinal study. The first few letters of longitudinal are long. This would be a long-term study, and there was no way to get an application in and be able to maintain your product in the market. So the Fifth Circuit said in a very colorful, and I recommend people go and read it, in a very colorfully worded decision, said that the FDA pulled a surprise switcheroo. And it quoted Romeo and Juliet Shakespeare, where it said that it sent the industry on a wild goose chase, saying to focus on marketing. They didn't even read the marketing. And then without having the requirement, or you could argue over whether, and many circuits, by the way, did not agree with the Fifth and 11th Circuit, which is why the court's probably taking this case. They said, well, it will be helpful, but not necessary. So the issue is, is the Fifth Circuit correct? Was the FDA arbitrary and capricious? Did it not follow the Administrative Procedures Act by not giving industry appropriate guidance as to what needs to be in the document? And then did it change the rules of the game at the end of the game, or perhaps even after the game? So it's not only moving goalposts, it's creating new goalposts after the game was over. And I think that's going to be the key issue here. And interestingly, it's the FDA that petitioned for the Supreme Court to review this case because they had lost in the Fifth Circuit, and the FDA was in a really tough bind because on the one hand, while the FDA did prevail in most of the challenges around the country, the industry said Fifth Circuit wrote a really strongly worded opinion on this, so we're just going to do some business in Texas and we're going to be in. And the FDA saw that as untenable and said we can't, and one of the reasons, more broadly speaking, that the court likes to take these split circuit cases is because we need to have one set of laws in this country. And if industry says, okay, well, we can't operate in most places, but we can operate in the Fifth Circuit, then what started happening was industry started moving into that Fifth Circuit legitimately, so there was proper jurisdiction. And then the FDA basically had no jurisdiction. So that's why they petitioned that a court that they, I think, recognized the makeup, especially in this post-Chevron era, is skeptical of agencies behaving kind of at will beyond what Congress gave them the authority to do. It needed to be addressed, even though the odds are probably against the agency. If you had to take bets, you would say that the current makeup of the Supreme Court is probably maybe not as extreme to the right as the Fifth Circuit, but certainly is sympathetic with some of the arguments about the regulatory state going rogue. A lot of people have asked the question, and I welcome questions later, but how does this affect, how does Loper living in the post-Chevron era, how does this case play out differently? And I would argue that you don't need to have overturned Chevron to recognize that the FDA acted in violation of the Administrative Procedures Act and didn't follow the Tobacco Control Act by changing the rules of the game after the game. But certainly, in the post-Chevron era, we certainly see that the court doesn't have much patience for agencies kind of making the rules on their own, and in this case, making the rules after the game was over. So I think there are a lot of things to watch here that affect the e-cigarette industry per se, but also have a major impact on how the agencies act and how industry is expected to play by the rules when they don't know the rules. So you don't need Chevron to be overturned for a court with the makeup of this one to be pretty skeptical about what the FDA has done here. But one of the things that I love about the Federalist Society is that we like to look at both sides of the issue. And certainly the FDA has some pretty good arguments on its side to defend its actions. The one arguments that it made in the Fifth Circuit where it did not prevail was that it didn't matter anyway. These products were not going to get authorized regardless of the rules. And you can evaluate the merits of that argument as you will, but it's an argument that the FDA chose as probably one of their best arguments in this case, that it didn't matter anyway. And they simply said, well, and the FDA actually said this to the Fifth Circuit, it doesn't matter because we're going to review this. If we don't prevail, we're going to review these applications and then we're going to reject them again. So that's really the strong argument that the FDA made, whereas the other arguments the FDA makes are on a public policy level, is that when we weigh the risks and benefits of these products, we don't want kids using them, and that's really important. So there's not much that can outweigh that. And the few products that were authorized were products that did not appeal to adult smokers very much. They also don't appeal to kids, which is why the FDA said, fine, these are appropriate for the protection of the public health, and the others aren't. What I would say is to look out for a very interesting thing is that the FDA has an opportunity to authorize a flavored product, menthol flavored products that have technology built into the e-cigarette. Maybe you have to put your thumb on it to validate who you are, that you're an adult. And the FDA could very easily improve their chances of winning this case by authorizing that Juul e-cigarette with menthol and perhaps other flavors, because they've done their work, their marketing and their product development to make sure that kids aren't using them. But surprisingly, we're just about a week away from oral arguments, and the FDA hasn't done that yet. So it's an exciting time, both if you're following the e-cigarette space as well as administrative law. And that's how I'll conclude.
Thank you very much, Jeff. On to you, Eric.
Thanks. Talking about United States versus Scrimetti. So over the past maybe 4 or 5 years, 26 states have passed laws banning or largely restricting gender transition procedures for minors. And this is the first time the court has taken up a review of one of these laws. So this case arises out of the Sixth Circuit. So the main focus here is whether Tennessee's law violates the Equal Protection Clause. The district court said that it likely did and granted an injunction. The district court said that this law was subject to heightened scrutiny under the Equal Protection Clause and was likely unconstitutional under that standard. The Sixth Circuit said no, the proper level of review is rational basis, and Tennessee's law survives scrutiny under that status. So that's kind of, I think, the big question is, what is the standard of review here? So the United States, its argument in brief is, yes, the law expressly mentions sex and therefore it is subject to heightened scrutiny. This is sort of a Bostock type analysis. That was a Title VII case. This is equal protection. The United States says the same basic logic should apply here. So let's just say, for example, a youth suffering from gender dysphoria. And so if there is a biological male who doctor says you're suffering from gender dysphoria, I want to prescribe you estrogen. This law says if a male wants estrogen, no, you cannot get estrogen. But if a female wants estrogen, yes, you can. So that's the way the United States is framing it, that if you switch out sex, you get a different answer. So therefore, it's sex discrimination. Tennessee says no. Several arguments that it has. Judge Sutton takes this standard and applies it to a wide range of laws. In his opinion for the Sixth Circuit, says that can't be right. There's a lot of laws that mention sex, and it can't be the case that all of these laws are subject to heightened scrutiny. Another argument is that Tennessee says we're not discriminating on the basis of sex, we're discriminating on the basis of a medical condition. And so we're saying that, we're not saying that girls can have estrogen and boys can't. What we are saying is that estrogen is a proper treatment for certain types of medical condition, but not for gender dysphoria. And that's something states can do, and states do often. One example is there's a good number of states, I think about 18, 20 or so states, that say that amphetamines or Adderall can be used to treat ADHD or other conditions, but the law specifically says it cannot be used to treat obesity. And obesity is considered by the federal government a disability, and you couldn't bring a disability claim that says you're discriminating me on the basis of my disability, saying that some people can have Adderall and I can't, and therefore I'm being discriminated against. So the Tennessee says this is a different medical condition and we're allowed to regulate on that basis. My colleague at EPPC, Ed Whalen, has also argued that rational basis is going to be unwieldy, and that the court needs to be aware that if it applies that standard here, it's going to be stuck, not only the Supreme Court, but lower courts too, stuck in just a whole bundle of cases with a wide variety of different factual scenarios. What about bathrooms? What about showers? What about housing in colleges? What about sports? That if you go down this road and you say rational basis applies to any sort of rule that treats a biological male who's presenting as a female differently than a female, then heightened scrutiny applies, that's just too complicated a road to go down. Another issue in the case is, how much does the medical consensus matter? And there, the first question is there a medical consensus? So there's a debate about a WPATH, the World Professional Association for Transgender Health. The United States says WPATH is the standard, and major medical groups in the United States have endorsed its standards, which says that this is necessary treatment for youth with gender dysphoria. But the other side says, no, this is an advocacy group. It has a clear bias, and sort of the political leadership of these major medical organizations, that is not really a proper way to measure a consensus within medicine. They also point out that WPATH itself has been subject to political pressure from this White House, including HHS, which pressured it to get rid of guidelines saying that these procedures are inappropriate for minors below a certain age. And so it's just further evidence that this isn't really an example of a medical consensus. Tennessee also argues that the that the United States is ignoring the Cass review, which came out of the United Kingdom this past summer, and looks to other developments in Europe, which have pulled back because of, quote, remarkably weak evidence for medical transitions for minors. And another issue is, how much does it really matter? And does the Constitution really state that some level of professional or scientific consensus bars states from passing a law that is otherwise obviously within the general police power to look after the health and safety of its citizens, especially its minor citizens? And then more broadly, even beyond this issue of medical consensus and what is the state's power to regulate medical procedures, I believe this case can be framed and should be framed as a debate over what is a human person and what's good for the human person. That's something that I wrote an amicus brief on behalf of my institution, the Ethics and Public Policy Center, that the core of this argument is about what's the relationship between a person's body and their identity. Are they separate? Are they the same? And that is the sort of a philosophical question about what it means to be human. That is not something that is the subject of medical expertise. This is a quintessentially political question, and legislatures are competent to, and it is right in their wheelhouse to debate these sorts of issues. So, I think for Tennessee, what it would say and what it has said, it pushes back on this idea that it is expressing animus towards minors suffering from gender dysphoria and saying no, that Tennessee is taking into account serious questions about the underlying science, testimony from detransitioners, and it believes that it is acting in the best interests of its citizens with gender dysphoria, particularly minors, and that there is a debate about how best to sort of care for and protect these people, and it is unfair and inaccurate to charge it with animus. So a lot of interesting issues in this case. I agree with most prognosticators, which are saying I think it's likely that the court will come down and agree with the Sixth Circuit and hold that rational basis is the proper standard here, and will affirm the Sixth Circuit's decision. Thank you.
Thank you, Eric. Next, we'll hear from Alexandra.
Thank you, Tessa. So I'm going to cover Coussis versus United States, which is an extremely important case in the criminal space about the scope of the federal wire fraud statute, which, along with its similarly worded companion, the mail fraud statute, is among the most important tools in federal prosecutors' arsenals. So the statute makes it a crime, a federal crime, to devise or intend to devise any scheme or artifice to defraud or for obtaining money or property in connection with an interstate or foreign wire. And this case is really the latest in a line of cases in the court's modern jurisprudence on the scope of the mail and wire fraud statutes, which dates back to McNally versus United States in 1987. At that time, for several decades, lower courts had developed what became known as the honest services fraud doctrine, which allowed prosecutors to use the fraud statutes very expansively to target schemes that involved intangible rights, such as kickback schemes involving public officials, like in the McNally case. And in that case, however, the Supreme Court held that the statutes do not go so far. They are limited to schemes to deprive others of money or property in the traditional sense, which does not extend to things like intangible rights to honest services of public officials. And the court cited, among other things, besides the text and history of the statute, federalism and fair notice concerns with a broader interpretation, and said if Congress wants to go further, it can. Congress then enacted a separate statute on honest services, and eventually the Supreme Court pared that back as well. But while this was all going on, federal prosecutors, sort of not surprisingly, wanted to try to see if there were other ways they could go back and try to expand the scope of the mail and wire fraud statutes again. And a doctrine called the right to control doctrine was essentially invented probably in the Second Circuit, which basically held that deception or fraud in order to, as the court said, deprive someone of the right to control their use of assets by depriving them of potentially valuable economic information was a property fraud. And that doctrine was alive and well in the Second Circuit and some others for almost 3 decades, until finally in 2023, in a case in which I was involved for one of the defendants called Simonelli versus United States, in a unanimous opinion, the Supreme Court held that this is not a traditional property interest that is covered by the statute. And there were several other cases before Simonelli, including a case called Cleveland in 2000, and a case called Kelly, otherwise known as the Bridgegate case, in 2020, in which the court also said federal prosecutors were going too far because they were targeting frauds where the deception was not directed at, taking someone's money or traditional property, but rather the so-called object of the fraud involved some sort of regulatory interest. In Kelly, it was of the state of Louisiana to issue poker licenses, and in Cleveland. And in Kelly, it was Kelly was the case involving Governor Christie's aides shutting down certain lanes in the George Washington Bridge, and there the state's regulatory interest for running the bridge was at stake, but there was no money or property that was the object of the fraud by these officials, and therefore it wasn't a property fraud. So what this case, Coussis, is about is another doctrine that federal prosecutors have tried to use to broadly expand the scope of the statute, called the fraudulent inducement doctrine. And the government has been particularly aggressive about invoking this doctrine in the wake of the Simonelli decision, which held that the right to control wasn't a valid theory of fraud. And basically, under this doctrine, the idea is that any lie to induce a transaction is sufficient to prove a scheme to defraud, and that the government doesn't have to show that the object of the scheme is to harm the victim's property interests. For instance, typically when one thinks of fraud, one thinks of, in connection with a transaction, you're lying to induce someone to part with their money, let's say to buy something from you, and then you're not giving them fair value in exchange. You're giving them something worth less than their money, as one example. And so the government argues that it doesn't matter. Essentially, they brought this argument first in Simonelli. Simonelli involved an alleged bid rigging scheme in which contractors in New York State had allegedly rigged a process to try to compete for contracts for something known as the Buffalo Billion Project, which was a development project in certain upstate New York cities. And there was no evidence in the case that once these defendants who did obtain contracts and did build projects in both Buffalo and Syracuse, that they had defrauded the victim. They actually built these projects to spec, provided what was delivered. There was no evidence of any loss or anything like that. And in that case, to try to defend the conviction, even though this theory had not been presented to the jury, the government argued, well, it's enough that they lied by rigging this bidding process to obtain the contracts, and the contracts were worth millions of dollars, and that's sufficient. The court said, we're not going to reach that because that's not the theory that was presented to the jury. So that question was left open. And there's a circuit split on whether this fraudulent inducement doctrine is a valid basis for mail-in wire fraud. And a pair of Third Circuit's decisions essentially adopted the government's view of this. Coussis was one, and then there's another case called Barat versus United States, which the court I'm involved in, full disclosure, we filed our petition at around the same time, and the court has held the Barat case, which involved the former dean of Temple University's business school, who was alleged to have participated in a scheme to provide false information to U.S. News in connection with their rankings of the business school. And if I have time, I'll talk a little bit more about that. But Crucis itself involved a contractor who won a bid for bridge repair projects in Philadelphia. The way the project worked, the winning bidder just received a fixed fee from the Pennsylvania Department of Transportation. The petitioner's bid was the lowest by several $1 million for each project, and the contracts that they obtained were very complex and had, among other things, various regulatory and compliance provisions, such as Buy American provisions, compliance with various environmental laws, and so forth. And what's at issue here is that, in addition, the contracts provided that the contractors had to make a good faith effort to spend a certain percentage of their earnings from the project on so-called disadvantaged business enterprise, or DBE, contractors. And the petitioners in this case caused their primary contractor to report per the contract that it was getting paint supplies from a pre-qualified DBE, when in fact the DBE was a mere pass-through and the supplies actually came from a non-DBE contractor. The petitioner paid the DBE a 2.25% markup, but there was no economic impact on the Pennsylvania Department of Transportation because it had just paid a flat fee. It was the petitioners who incurred the extra cost by this scheme. The Third Circuit upheld the conviction and held that this misrepresentation about DPE participation was sufficient to prove federal fraud because it affected the nature of the party's bargain, and that also because petitioner had used the false statements about the DBE to earn millions in revenues from the contracts. And the decision came out around the same time as Simonelli, and the Third Circuit simply kind of dismissed Simonelli's relevance in a footnote and essentially held that as long as money or property changes hands, a misrepresentation like this is sufficient to affirm a conviction for wire fraud. So the question presented is, whether a scheme to induce a transaction in property through deception, but which contemplates no harm to property interests, constitutes a scheme to defraud under the statute. And the petitioner argues that the answer is no, relying among other things on a body of precedent holding that when Congress uses a term that is a commonly used term like fraud, that courts are supposed to look, unless there's an indication to the contrary, which there isn't here, courts are supposed to give it its common law meaning. And they argue that under the common law, fraud required an injury to property. They also cite Supreme Court precedents involving the mail fraud statute going back to the early 20th century. They also argue that in the particular context of this case, to the extent the state had, PennDOT rather, had an interest in this DBE provision, that interest is regulatory, it's not a property interest. And then they cite, again, as in Simonelli and some of the older cases, federalism and fair notice concerns, and argue that under the government's theory, the statute can be interpreted incredibly expansively and would cover and make a federal crime out of a limitless variety of deceptive actions traditionally left to state contract and tort law, despite the Supreme Court's directive not to do that in Simonelli and earlier cases. They give some interesting hypotheticals. For instance, if a babysitter applies for a job and claims that she's going to use the money for her studies in college, but in fact she goes out drinking, is that suddenly a federal fraud? My Peratt case, I think, is quite interesting too, because what that case was about was false information being provided to U.S. News which even the government's witnesses at trial and many people know, the U.S. News rankings are, these witnesses at trial said they were stupid, they were pernicious, they had very little to do with the actual educational quality being at the schools. And yet now it's the federal government is turning sort of accuracy of these rankings or information provided for these rankings into a federal crime. The government, for its part, it argues principally that the text of the statute supports its position, because the statute provides that if the object of the fraud is, quote, obtaining money or property by means of false or fraudulent pretenses, representations, or promises, then a crime is established, assuming the wire or mail is proven. And on the other hand, and they say, there's no textual basis for inferring any requirement of harm to property or intent to cause loss. On the other hand, the defendant points to a number of aspects of some of the precedents and the court's interpretation of it, which it argues, the defendant argues, supports its position. The government also claims, as it did in Simonelli, and another issue that the court didn't reach in Simonelli, that these hypotheticals about overexpansive application will not come to pass, because the government claims in the Supreme Court in its briefs here that materiality is a demanding and rigorous standard, and that what it refers to as an essence of the bargain test is sufficient to ensure the statute doesn't have an overbroad scope. Interestingly, that position, which stems from a Supreme Court case interpreting a different statute, the False Claims Act, is inconsistent with the position that prosecutors typically take in the lower courts at trial and on appeal in the circuits, where they argue for a much lower standard of materiality, which is supported by the Nieder case by the Supreme Court. The government also relies on some bank fraud cases from the Supreme Court that it argues don't require any intent to cause loss, and it posits its own set of hypotheticals and says, for instance, that the petitioner's position is much too narrow, and wouldn't cover something like a person says, I'm selling you my season tickets to the Jets football games, and instead gives this Jets fan Giants tickets of equivalent value, and how can that not be a fraud? So those are just a few examples, but I think the case, there are a lot of interesting hypotheticals that I suspect will be tested during the argument, and the decision. I don't want to venture a prediction. I obviously have a stake in the outcome here for some of my clients, but it'll be very interesting and could be a very important fraud decision going forward. And if in fact the court rules against the government, I suspect federal prosecutors will go back to the drawing board and try to come up with some other creative theory around the decision, but time will tell, and we'll see what happens.
Thank you, Alexandra. On to you, Boyd.
Thanks, Tessa. So I'm going to be talking about Feliciano versus Department of Transportation. This case is about how much reservists are paid when they're mobilized for active duty service under a federal statute. So to kind of fully grasp that question, you have to take a step back and just kind of talk about the lay of the land. So about 1 million Americans serve as reservists. These are people that typically work a civilian job, but they can be called up to active duty military service at a moment's notice. There is a situation here where reservist civilian jobs often pay more than the military does when they are called up to active duty. There's this, difference in pay, and so that results in this situation where reservists are effectively penalized for serving the country. When they agree to become reservists and they are called up to active duty, they take a financial hit. And a lot of people have recognized this as a problem, and I mean that in like the sense of a public policy problem for a lot of different reasons. And so for many years, states and even private businesses have agreed to essentially pay the difference. They say, you know, while you're mobilized, we'll pay you whatever the difference is between your civilian job and your active duty pay. And that's called, intuitively enough, differential pay. In 2009, Congress passed a statute that provides differential pay for federal civilian employees. So if someone works at an agency and they're a reservist, the government will pay the difference between the agency salary and the reserve salary when they're called to active duty in certain circumstances. And this case is basically about when the government will pay this differential pay difference. So I'm going to glance at my notes here because this case is a statutory question. It is very textualism heavy, so the words are really important. So I'll preface this with, like all, you know, many federal statutes, there's kind of like a Russian nesting doll structure here where, you know, there's like a cross-reference to a cross-reference. But kind of the bottom line is that reservists are entitled to differential pay when they're mobilized, quote, under, end quote, 9 different enumerated provisions, quote, or any other provision of law during a war or during a national emergency declared by the president or Congress. So differential pay if you're in one of 9 enumerated categories or any other provision of law during national emergency. So in this case, Feliciano, the petitioner, is a federal employee. He's an air traffic controller at the FAA. He gets called up to active duty as reservist for the Coast Guard. He escorts ships coming to and from domestic ports. It's not under one of the 9 enumerated provisions. It's under a different provision. And he asks the government for differential pay. And he says, I'm not under one of those 9 provisions, but there's a national emergency currently going on. And there's been a national emergency declared by the president since shortly after the 9/11 attacks. That's still ongoing to this day. And so he says, it's during a national emergency. I was called up under a provision of law, and the statute says you get differential pay if you check those boxes. And the government, the Merit System Protection Board, citing a federal circuit case, says that's not enough. You have to be called up in some way that is kind of substantively related to the national emergency that is in effect. And if you don't have that substantive connection, then no differential pay. Feliciano petitions the Supreme Court. Supreme Court has granted the case. So I'm going to get into the arguments that each side makes here, but I also just want to disclose me and my colleagues filed an amicus brief on Feliciano's side. So I'm going to do my best to give both sides, the best version of their arguments, but I just want to be clear about that. So Feliciano's argument, both sides' arguments really come down to what the word during means. Because remember, the key text here is during a national emergency. And so what Feliciano says is during refers to a temporal link, which sounds complicated, but really is not. It's basically just how we use the word during in normal day-to-day speech. So if I say I went jogging during the television broadcast, the only connection between the jog and the television broadcast is that they were at the same time. At least, that's Feliciano's argument. He says that's how people normally talk about during. He also cites a bunch of statutes that use during in a way that kind of can only refer to this kind of temporal overlap. He also says that structurally, the statute makes a lot more sense if all you have is a temporal link, because otherwise then you get into these kind of fuzzy questions about how closely related does the service have to be to the emergency, and then how can you figure that out ex ante to make sure you're getting your differential pay as you're serving. And so he says there's a host of workability questions. Feliciano also cites legislative history, a lot of floor statements that seem to suggest that during has kind of this ordinary meaning, a Congressional Budget Office scoring that seems to assume that all reservists are going to be getting differential pay when they're mobilized, which kind of only makes sense if that includes everyone during a national emergency. And he cites an amicus brief submitted by some members of Congress, including sponsors of the bills that eventually were enacted in the differential pay statute. And then the last thing Feliciano points to is the pro-veteran canon. Even though it's called the pro-veteran canon, it applies to service members more broadly. And basically what it says is if the statute is ambiguous, you should break the tie in a way that's going to favor the service member, because we presume that's what Congress would have wanted. So it's a substantive canon. So the government's response here is that the meaning of during is contextual. And kind of the semantic example they give is they say, well, oh, if you say an attorney argues during a hearing, well, you wouldn't mean the attorney is arguing while the hearing happens to be going on. Context tells you that he's arguing at the hearing. And so that doesn't get the government all the way. That just means context matters. But then they say the reason context here requires this kind of substantive link is because I alluded to this a little bit with the Russian nesting doll structure, but the actual cross-reference here is half the definition of this term contingency operation. The government says, well, since the definition here is operation, the word during requires a look at like whatever the operation is that's going on. So they say context matters, context here required, substantive connection. They also bring up, I would say, a quasi-surplusage argument. They say, well, there's been a national emergency going on for all these decades. And so if during has this literal meaning, then those 9 enumerated categories don't do any work. And I call this quasi-surplusage because there doesn't have to be a national emergency in effect. There just is one. So, in theory, if the national emergency's ended, then those 9 enumerated categories would do work. But that's one of their arguments. They also hit back on this workability point, and they say, well, there's actually not going to be that many hard cases because it's normal Department of Defense policy to specify whether reservists are being called up in support of a contingency operation. And they typically say which contingency operation, and they say you can always ask for clarity if you're unsure. And then the last thing they say is the pro-veteran canon doesn't come into effect at all, because that canon only applies when there's ambiguity. They say the statute is so unambiguous in their favor that you don't need a tiebreaker, in the case of ambiguity. So I'm also not going to make a prediction on this one, but I think that there's 2 kind of interesting things teed up in this, I think, case that otherwise just looks like, a good old-fashioned like battle about textualism. So one is kind of like how we're going to interpret statutes in a post-Chevron world where there's an agency involved, and especially this kind of contextual argument the government is making, because it almost has a flavor of Chevron. So if I were to try and put their argument in Chevron terms, I would say, well, during is susceptible to multiple meanings, and I'm the government, and I'll tell you, like, the statute functions a lot better if during means what we say it means. And of course, they don't frame the argument that way, but there is kind of that flavor of it. And so I think there's a question here about how much, contextual arguments can help the government advance kind of policy positions that are no longer formally acceptable post-Chevron. And then the second thing here is the importance of substantive canons. So as I mentioned, both sides say, they have the best unambiguous reading of the text, so you don't even need to get to the pro-veteran canon. I think that partially might be a function of this case last term called Rudisill, where 4 justices expressed some skepticism about the pro-veteran canon and substantive canons more generally. So it'll be interesting to see if someone touches on that this time around. But that's all. Thank you.
Thank you, Boyd. And next we will hear from Michael.
Thank you, Tessa, and thank you very much to the Federalist Society for inviting me. I'm here to talk about 7-county infrastructure coalition, the Eagle County, Colorado. Full disclosure, Americans for Prosperity Foundation, joined by the Competitive Enterprise Institute, filed an amicus brief in support of petitioners. And my remarks are my own, all errors and omissions mine. Now, the question presented is whether the National Environmental Policy Act requires an agency to study impacts beyond the proximate effects of when which the agency has regulatory authority. In other words, it's about the scope of the study the agency must perform. By way of background, NEPA was enacted passed by Congress almost unanimously in 1969 and signed into law in January 1970. And it simply required the federal agencies to study with respect to major federal actions significantly affecting the quality of the human environment, and prepare a detailed statement regarding environmental impacts of the proposed action, any adverse environmental effects which cannot be avoided from the proposal, et cetera. It also created an agency called the Council on Environmental Quality, CEQ, within the Office of the President as a sort of an advisory body, but did not give CEQ, rulemaking power. And it's sort of, some time passed, and it also did not create a cause of action for affected parties to, seek judicial review. So some time passed. In 1977, President Carter issued an executive order requiring CEQ to issue binding NEPA regulations to cover the whole federal government. CEQ did so. They had definitions of direct effects, indirect effects, which are caused by the action and farther removed in distance or time, but reasonably foreseeable. Fast forward over time, and again, NEPA was enacted before you had Supreme Court decisions, expanding Article 3 standing and sort of opening up wide for judicial review. Over time, project opponents use NEPA to block, as a tool to block a number of projects. Courts found it was reviewable under the APA, and it's sort of an expanded, along with the CEQ regulations, the scope of what the agency must study. Over a series of Supreme Court decisions, the Supreme Court repeatedly and unanimously, ruled in favor of the government and against the petitioners on the scope of what must be studied. And as relevant here in Metro Edison Company versus People Against Nuclear Energy, they ruled that the scope of the environmental effects that must be studied must be, needs a reasonably close causal relationship between the change in the physical environment and the effect, and that but-for causation was not enough, and that linked the scope of the required study to the concept of proximate cause. Later, in Department of Transportation v. Public Citizen, the Supreme Court again so ruled and held that the scope of the study should be limited by the effects that the agency has the legal authority to control and is legally responsible for. In other words, things within its jurisdiction, also reaffirming NEPA's rule of reason. So as relevant here, in the some lower courts got the message, I would submit, and sort of held that the scope of the effects that must be studied is limited to, what's within the agency's jurisdiction, what it's responsible for, and the specific project that's being studied. Others, like the DC Circuit and the Ninth Circuit, reached a different conclusion in a line of cases, beginning with a case, Sierra Club v. FERC, which is known as Sable Trail, where the DC Circuit in a 2-1 decision found that the agency needed to study environmental effects outside the scope of the proposed project and also outside of its jurisdiction, specifically downstream effects. Now to the instant case, you have the Uinta Basin in Utah is resource rich, but it's remote, and the only specifically it has a lot of waxy crude oil, which it can only transport on two-lane highway to and from, and it wants to build a railroad to connect that to the national railway. They petitioned the Surface Transportation Board, a federal agency with a pro-development mandate, for approval and seek expedited review. This requires an environmental impact statement. The agency, over a period of a couple years, seeks public comment, prepares an draft EIS that covers everything from geology, water resources, special status species, vehicle safety, everything relating to the project itself. It holds public meetings, responds to the comments, and ultimately it issues a preliminary approval and then ultimately approves the project along subject to mitigation measures, issues a 3,600-page EIS for an 88-mile railway track, addresses and even, yes, there are going to be upstream impacts potentially from the, oil wells, which are covered by, those are third parties and other agencies and other federal and state agencies in environmental review. But there are also, there are, potential downstream and downline impacts, for example, on the Gulf Coast from the increased refining. And nonetheless, petitioners, where the various environmental groups and Eagle County, Colorado, which are hundreds of miles away, and Eagle County is where you have like Aspen and Vail, as I understand, they opposed the project and filed petitions for review in the DC Circuit under the Hobbs Act. The DC Circuit, following Sable Trail, ultimately determined that what the Surface Transportation Board, again, which is tasked with economic regulation as opposed to environmental or even railroad safety regulation, did was insufficient, and faulted the board for not studying in sufficient detail upstream effects covered by third parties and other agencies outside of its jurisdiction, as well as because it didn't study the effects at the refineries, the downstream effects, and even down train effects, or downline effects, I should say. For example, if a train from the railroad gets on a different line, and then by whatever happenstance, something might happen. So that's the issue here: is what is the proximate cause, or what is the causal relationship, and what is the scope of what an agency must study under this statute, which again is not a substantive statute, but a procedural one that cannot, put the scale. It can only prevent uninformed agency decision making, not, unwise, if you will. Adding a wrinkle to it, the NEPA statute itself was amended to add reasonable foreseeability language into the statute itself as to the effects that must be studied, also further confirming that it's the agency, the proposed agency action, like the specific agency action at issue, that must be studied. I think it was shortly before oral argument or before a decision was issued, but the case was decided under the old Builder Act, or I'm sorry, the NEPA before the Builder Act. And in between, the agencies has sort of changed their, or CEQ had changed its NEPA regulations a couple times. So the issue before the Supreme Court is whether, as petitioners would argue that the scope of the effects that must be studied are limited to the specific project at issue and the proposed agency action and the what is proximately caused by or what's proximately caused by that action, as opposed to the independent actions that may or may not flow in the future and decisions by other agencies doing other environmental reviews and other third parties. The government, although they opposed the federal respondents are actually supporting the petitioners in this, but arguing for a sort of a Goldilocks rule where it's what the DC Circuit or what the Surface Transportation Board did was sufficient, but they reject the petitioner's more bright line, drawing a line at the agency's power and the specific action at issue and what directly flows from that, subject to the rule of reason. And the environmental petitioners, they seem to focus more on reasonable foreseeability is enough. Another wrinkle is that, again, as I foreshadowed, CEQ has never been given, specific rulemaking authority, and this is sort of floated out there. Do they have this power, or where it's can the president confer on an agency by executive order the authority to make binding regulations for the entire, government as well as the courts and public. Shortly before the reply briefs were due, the DC Circuit found 2-1 that in fact CEQ does not have this power. And again, this whole body of NEPA precedent had built up around, the lower courts interpreting CEQ regulations as binding. So it's both the petitioner and the federal respondents have cited this in the reply brief. So it will be very interesting to see how the court goes about this line drawing exercise, and whether they explore the broader issues or focus. And I will not predict how the court will decide the case, or focus more on the government's middle of the road position or the petitioner's position on limiting to proximate cause. With that, I'll conclude my comments, and thank you very much and welcome any questions.
Thank you, Michael. We have 3 more cases to cover before we move into our Q&A session. The first of which comes to us from the 10th Circuit. The case name is U.S.V. Miller. And so for context, in 2014, a corporate debtor paid $145,000 to the IRS to cover personal tax debts of 2 of its corporate officers. And then 3 years after making that payment, the company filed for bankruptcy. So backing up, the U.S. Bankruptcy Code allows for a bankruptcy trustee to take back a payment that was made within 2 years before filing for bankruptcy. Trustees usually do that by filing a lawsuit, and then they use that money to pay off creditors. Relatively common practice. So the key issue here in this case, U.S.V. Miller, is that the federal statute allows for this clawback to happen within 2 years for a payment that was made within 2 years before filing for bankruptcy. But the federal statute allows you to turn to relevant state law as well to claw back a payment. And in particular, in some jurisdictions, most jurisdictions, trustees have longer than 2 years to claw back a payment. Most states have a clawback period of 4 years. So the issue here is that in order to turn to state law, as opposed to using the 2-year standard under federal law, a party has to show that an actual debtor would have been successful, an actual creditor, excuse me, would have been able to bring a lawsuit outside of bankruptcy. And in this case, we have the federal 2-year clawback period at issue with the state clawback period of Utah, which is 4 years. So the government's argument here is that the government's saying, hey, you have to show that an actual creditor would have been able to bring a lawsuit outside of bankruptcy under state law. And trustee, you just can't do that here because we have sovereign immunity that protects us against lawsuits seeking to undo payments beyond that 2-year period. So the issue that the Supreme Court will be answering this upcoming session is that whether bankruptcy trustees can claw back payments beyond the 2-year period, or whether they can turn to the state law and claw back payments beyond the 2-year period. Does federal immunity prohibit that? There's a circuit split here. The 10th Circuit, which is this case, the 9th and the 4th allow bankruptcy trustees to claw back payments beyond the 2 years, whereas the 7th Circuit does not. They stick to that 2-year period because of sovereign immunity. The next case is Republic of Hungary versus Simon, which comes to the Supreme Court from the DC Circuit. We're going to talk about treasure for just a minute. We don't get to do that often in the law, so we'll do that today for just a brief moment. Welfenschatz in English, the Guelph treasure. It's a collection of 82 pieces of medieval art, and this case has a long procedural history that we won't go into. But what we need to know for today's purposes is that according to the lawsuit, back between World War I and World War II, a consortium of Jewish-owned art firms in Frankfurt purchased the treasure, but they were coerced into selling it to Prussia for a very small value, a third of its actual value in 1935. So 3 descendants of consortium members sued in the U.S. District Court in 2010, asking for compensation from Germany and the Prussian Cultural Heritage Foundation. So the question here is, if you caught this, the plaintiff sued in the U.S. District Court, and we have foreign entities here in question. So the question here is, does the United States have jurisdiction over the matter? And we turn to the Foreign Sovereign Immunities Act to answer that question. Under that act, the U.S. has jurisdiction over foreign states when rights and property are at issue. Property was taken. The taking was in violation of international law. And here's the important one for this case. The property or its proceeds are present in the United States in connection with a commercial activity carried on in the United States by the foreign state. So this is the jurisdictional hook that the plaintiffs claimed. And the argument is that the property, the treasure, was seized in violation of international law. And when the property was liquidated to currency, that currency in possession of the Hungarian state was historically commingled with other state funds. And some of those funds are now being used in connection with commercial activity here in the United States. So their position is that because of that historical commingling, the United States courts have jurisdiction under the Foreign Sovereign Immunities Act, excuse me. So the DC Circuit said that the plaintiff can rely on plausible allegations. They don't have to actually trace the confiscated assets to the United States. They just have to make plausible allegations, whereas the 2nd and 11th Circuits found differently. They say that plausible allegations just aren't enough, that plaintiffs need to point to affirmative evidence that the property can be traced. The final case comes to us from the 4th Circuit. This is Dewberry Group Incorporated versus Dewberry Engineers Incorporated. 2 companies with Dewberry in the name. this is how we got to where we are. One of these companies is a real estate developer in the southern in the southern US, and the other company is a civil engineering and surveying firm. So they've had past arguments and disputes about the use of the name and reached a confidential settlement in 2007. That's fine. But fast forward to 2020, the Dewberry Engineers Group sued Dewberry Group, saying that alleging breach of contract and trademark infringement, presumably based on what they had agreed upon. The court found in favor of Dewberry Engineers, and this is important, it awarded profit disgorgement. So here, the issue that the Supreme Court has to answer is when we're looking at profits and we're deciding how much the prevailing party should receive and disgorge profits, do we look at just the violating entity, just the company that breached the contract, just the company that infringed upon the trademark? Or are we going to take a step back and are we going to look at the aggregate profits across the entity, but also its corporate affiliates? So here we have some strange piercing of the veil questions here. We won't go into the details, but again, we have a circuit split where the district court and the Fourth Circuit both say, no, we're not going to pierce the corporate veil. We're going to stick with just the profits of the corporate entity. And I'm realizing I just misspoke. The district court and the Fourth Circuit do pierce the corporate veil, and they look at profits of corporate affiliates. Whereas the Ninth Circuit and the 11th Circuit say we're going to just look at the profits of the infringing entity when we're considering profits in our analysis. So that concludes the remaining three cases. I'd like to move into a question and answer section. So panelists, I'll be calling upon you again. We got a question specifically for Mr. Garrett, and I'll read you the question, and while you can think about this answer. So our question asker says, it doesn't sound like any military policy, regulation, etc., is implicated, which might trigger traditional court deference to government action. But just to confirm that's correct, especially since it sounds like the petitioner was not mobilized in support of any specified authorized contingency operation. Could you maybe speak to that, Boyd?
Yeah, happy to. And thanks for the question. So yeah, just to be clear, like no one is asking for formal deference here, and they couldn't, certainly like post-Loper. But I was just kind of pointing out that like the context argument, if you squint hard enough, kind of looks a little bit like a policy-laden kind of Chevron argument. But yeah, here, there's kind of it's a little bit in dispute, but the orders did reference a contingency operation. And here, though, I mean, the parties, Feliciano himself says that shouldn't really matter. He shouldn't have to have any evidence of a contingency operation. All that matters is this temporal link, and that all comes down to the meaning of the word during. And that is just kind of like a pure legal question that a court has to review de novo.
Thank you. We got another question for Jeff specifically. So, and part of this is a comment. So our question asker has said, to put matters into context, FDA predicted in its 2016 fiscal analysis for the rule, which brought vape products under its jurisdiction, that the marketing review process would take out a significant number of products. It begs the question how FDA knew that 4 years in advance. FDA also predicted that no more than 2,500 applications would be received. But then it received approximately 7.5 million applications. Could you speak to this, Jeff?
Thanks, Tess, and thanks to the question asker. Very informed question, and that's accurate. But I think it's an important data point. But it may have been simply the FDA telegraphing that its interpretation of appropriate for the protection of public health, as it was creating this rule called the deeming rule. It deemed e-cigarettes to be tobacco products, which it had authority to do from Congress, that it thought it would be a very high standard, that the FDA was saying, as we have this scale, we are going to consider the risk of, particularly of youth using these products, as a very heavy weight. I don't think that's in violation of the law. And while I do think it's an important data point that tells us how the FDA predicted how it's going to see these issues, I don't think in the context of all of the other facts that are out there and some of the arguments that the plaintiff in the underlying case, Wages, made, and how the Fifth Circuit saw it, was that there are a lot of very other critical issues. So while I think FDA's initial stance that it's going to be a high standard is an important data point, I don't know whether it will be dispositive in this case or even an important factor. But it's true, and certainly the FDA, if you take its prediction on its face about the very low number of applications, while the entire industry at the time was saying, and this matters because the deeming rule put into play everything that happened afterwards, that required, as I mentioned earlier, a individual pre-market tobacco application for each individual SKU. And industry said, well, why don't we just have a standard, and then the application can cover a range of products, and if there's a difference in each product, then we can address that. If there's a different flavor, certainly, if you have a typical cherry flavored e-cigarette, which are widely used by adult smokers to quit, and then some irresponsible company sells a gummy bear flavor as well, then maybe that would require a different analysis. But I don't think that's really even what's coming out in this case, and I don't think you're going to hear much about that on December 2nd during oral arguments, where I will be live tweeting oral arguments on this live Xing or tweeting on December 2nd, Jeff A. Steyer, S-T-I-E-R.
Thank you, Jeff. I'd like to take the opportunity to open up the floor to any of our panelists who may have questions or comments about something that was said earlier in our program in our remaining 7 minutes. And also accepting other questions in the Q&A feature on Zoom. Okay, well, seeing none and hearing none, this will conclude today's program. Thank you all very much for joining us. Thank you again to our great panelists for your time and expertise. We are adjourned. Thank you.